There are some deductions that require the Secretary of State to approve before they can be deducted. For example, the contractor doesn't benefit directly or indirectly from the deduction if it's not prohibited by law, if the employee voluntarily consents to the deduction in writing ahead of time prior to the work being done, if the deduction is not prohibited by the collective bargaining agreement, and if it serves the interest and convenience of the employee. Some deductions that are not allowed are not being paid overtime pay, which is time and a half, for any hours worked over 40 hours. There are some exceptions. Taxes that the employer is required to pay is also prohibited. Workers' compensation insurance costs should not be deducted from an employee's paycheck. And deductions that bring the worker's minimum wage below the minimum wage as stated under the federal FLSA. And then deductions that cover the cost of OSHA required equipment. That's also prohibited. The cost of uniforms when required by a law, the nature of the business or the employer. The cost and maintenance expense are to be paid by the employer. If the employer requires the employee to pay, then the employee's wage rate may not be reduced below the required minimum wage rate set by the FLSA. The cost of any items that are considered primarily for the benefit or convenience of the employer would have the same restrictions as uniforms. Tools used in the employee's work, damages to the employer's property, financial losses due to clients or customers not paying their bills, theft of the employer's property, making deductions that lowers the employee's wage rate below the required minimum wage rate set by the FLSA, photographs if required by the employee for employment, bond if required by the employer, business expenses, medical and physical exams if required by the employer, and gratuities. The employer may have a policy where tips are pooled and split between employees who provide direct table service to customers.